All right, I remember to hit record. Welcome everyone to the Friday edition of the Employer Handbook Zoom Office Hour, Beverage and Benefits Edition. Or beverages with benefits? I don't know. Beverages and Benefits Edition. My name is Eric Meyer. I am the publisher of the Employer Handbook blog. I am also an attorney in the employment practice group at FisherBroyles. And I am joined today by three of my colleagues, and I'm going to let them introduce themselves. Now, I don't know how this is going to show up on YouTube. We're recording this, and I will upload it to YouTube. So if you're watching this now, be sure to like and comment and subscribe and all that good stuff. So I don't know how it's going to look when we get to YouTube, but I'm going to do this Brady Bunch style and start with my immediate left. That way. Mark Mathis, how you doing?
I'm doing good this morning. Good morning, everyone. I'm Mark Mathis. I'm an employee benefits and executive compensation attorney at FisherBroyles. I've been doing this for slightly over 20 years and focus exclusively in all of the areas that you would expect from welfare plans and COBRA to qualified plans, executive compensation, equity. I do a lot of fiduciary structuring work for 401k plans because of lawsuits, as you may know. But we're here to talk about the next installment of guidance on the COBRA subsidy.
Yeah.
And so I'll pass it back to you, so Eric, so you can move on.
Amy, good to see you again. How are you?
Good. Thank you.
Tell everyone a little bit about yourself.
Okay. My name is Amy Epstein Gluck. I am Eric's employment law partner, who frankly, when there's a COBRA question, I call Mark or Bob. Now, there are some things that touch upon the employment relationship, obviously with COBRA under the new plan. And so I'll answer questions about that. I work with HR and small and medium-sized businesses with all of their employment law needs. Thanks for having me, Eric.
Thanks for being here. And the goateed handsome gentleman in blue, Bob, how you doing?
Hey, doing well. How are you? Thanks for having me today, or I guess all of us today, but technically me. I'm Bob Ellerbrock. I am an attorney at FisherBroyles that does employee benefits and executive comp. Anything from HIPAA to 401ks to pension plans, a little bit of everything. So just appreciate you having me today and talking about the exciting subject of COBRA.
Appreciate you being here. And folks, this beverages and benefits, this wasn't just manufactured out of whole cloth. This was Bob's idea. So there are a couple of ground rules for beverages and benefits. We won't judge you. We don't know what you're drinking off camera. We don't care. But we do have some ground rules. Every time we say it depends, you take a drink. Okay. But aside from that, remember, I got to get this disclaimer out now. We're not responsible for anyone who imbibes too much over the next hour. We expect you all to be responsible. We're lawyers. May not be the most responsible lawyers. Oh, yeah, we are the most responsible lawyers. We know a thing or two about COBRA and employee benefits, but we're not your lawyers today, okay? We're not giving legal advice. We're not creating any sort of attorney-client privilege. I do see some clients in here. For the next hour, we are not your lawyers, right? No one gets legal advice from a free Zoom, okay? If you need real legal advice tailored to specific facts and circumstances, please call your outside employment counsel. Other than that, I think we're good to go. Let's kick off with you, Mark. Well, you alluded to it in the introduction. There is a lot to unpack with this new Department of Labor guidance. So just get us started.
Yeah, on the 7th, the DOL dropped a bunch of notices in an FAQ. The FAQ is very instructive, as are the notices. But you know, the FAQ's 10 pages, but it's a must read. I mean, think of it as being on Oprah's list. The IRS agreed with DOL's positions as set forth in the FAQs and the model notices. but the IRS hasn't given us anything else. And if you attended the last version of this, or a couple of weeks ago, I was expecting a notice from the Internal Revenue Service, and they had done that with the American Recovery and Reinvestment Act back in 2009 when we first saw subsidized COBRA, but we haven't heard anything from that. But the last takeaway from what we've got to unpack is be ready to track a lot of deadlines and dates. Because there's going to be plenty to try to keep your arms around as you go through implementing this. And so with that, I'll turn it back to Eric, and we'll proceed through our list of items.
Sure. So DOL fact, you said it's 10 pages, a lot to take in. What are some of the top takeaways? And I'll throw this out to Bob or Mark. What are some of your top takeaways from the DOL FAQ?
So, and I'll start and let Mark do a couple, but fortunately, most of it made sense and kind of followed what we were anticipating it to go. It clarified that the termination had to be, or the qualifying event had to be involuntary. So someone could not quit and then decide that they were COBRA eligible and get the subsidy. Reduction of hours clarified that it would suffice as a qualifying event and be eligible for the subsidy as long as it was, within that time period. The problem with reduction of hours kind of remains the same, and that is it's not always perfectly clear. Based on the plan and everything like that, plan terms and everything. So, those were the good things. It doesn't really change, and I think we said this, and if you were in the first time a couple weeks ago, it doesn't change any of the rules of COBRA, right? It's just the subsidy and going back and paying for a certain period of time. I know Mark and I were talking a little bit, and I'll let Mark talk a little bit about some of the things that it does with regard to eligibility, where the subsidy is a little different than the COBRA regulations, with regard to when someone has to, if they're eligible for another plan or if they have to be enrolled in that plan. Mark, you want to talk about that for a second?
Yeah, this is a nuance that struck me whenever I was reading through the FAQs and I went back to the old COBRA regs. And if you have after acquired coverage, so if you become eligible for Medicare, you have new employer coverage, or you can go on to your spouse's coverage, for purposes of the subsidy, mere eligibility will suffice to cut it off. If you go back under the basic programming under COBRA, you have to be enrolled. And so that's a distinction that as you go out and you work with your TPAs and you tune your system up to go live with this, there are little distinctions like that are kind of embedded throughout this. And so when you're testing to make sure that this thing's going to operate correctly, that would be one of the things that you would want to take into account. Kind of circling back to the reduction in hours, there's a point that was drilled in my head whenever I was really learning COBRA back in the early 2000s, and that is you have to have the event and the loss of coverage. It's a two-part test. And so what you would do there is, on a reduction of hours, you would go in and look at your policies in the plan, as Bob alluded to see if that results in the loss of coverage. And there would be an eligibility issue. And so, you'll have facts, but they also have to result in a loss of coverage. And the employee has to be an employee when that does occur. And so, that's out there. There's a little bit of nuance there. We know that gross misconduct applies as it does under COBRA, so it'll cut off the right to the COBRA. All eligible employees who lose coverage are eligible for the customary separate rights provision of COBRA, meaning that anyone can go in there and elect as long as they're a qualified beneficiary. So for children, they would need to be covered the day before the qualifying event in order to be eligible to have that election made for them. And so there are a variety of different things that are out there like that go in and reiterate the regular COBRA regime in the way we're applying it.
There's a question that just came in, and I'll toss this out to either Mark or Bob. And by the way, folks, if you have questions, we'll have answers. We'll try and have answers, and we will say it depends. So
let me throw out it depends so everyone can get a sip right quick.
there you go.
Cheers.
Right. So the first question that came in, if you have questions, put them in the chat window and we'll do our best to answer them. First question from Paul. He wants to know, after 6 months, so I assume you're on the subsidy, you get your 6-month subsidy over, right? After 6 months, can an individual then switch and obtain a policy on the healthcare marketplace?
Yes, the FAQs actually address that, and the end of the subsidy or the end of COBRA will trigger the special enrollment period in the marketplace.
Great. All right. Oh, here comes one more question. And for a reduction in hours qualification, does that include voluntary reduction in hours in lieu of retirement? I think the answer was no, right? It has to be an involuntary, correct?
Well, the reduction of hours, there's kind of some speculation in the benefits plan community about whether or not a voluntary reduction, say I elect to go from full-time to part-time or whatnot, that will apply, provided they otherwise lose coverage. That's where it would be helpful if we had some guidance from the IRS on that, because as Bob noted, the definition of a reduction of hours is pretty loose in the COBRA regulations.
Oh boy, all the questions are coming. I will monitor the questions and we'll get to as many as we can, but I don't want to get too far off track. Probably should have kept my mouth shut with asking the questions in the chat window. I took us off track a little bit and I apologize. We were talking a little bit about kind of the customary separate rights rules, and that I guess we were segging into that the rights do extend back to pre-pandemic periods. I mean, that's an important issue for employers to address, that we're not just talking about people who prospectively drop hours or lose their job, but we're also talking about folks who may be on, may have been offered the opportunity to go on to COBRA last year, for example.
Yeah, and Eric, that's an important point, and that's going to be a date tracking issue as well. In the FAQs, the Department of Labor goes back to basically any qualifying event that was an involuntary termination or a reduction of hours that occurs on or after October 1st, 2019, which is pre-pandemic. In going through your data points to figure out that these folks are going to receive a special notice and they have a special election right, even though they may not have elected COBRA, or they elected COBRA and let it lapse due to non-payment, they're going to have the ability to go in and elect again, and that will be effective on April 1st, or the first payroll, or the first typical payment period after April 1st through the end of the subsidy, but it will stop short at the end of the natural 18-month extension. And so the 18-month extension can expire within that April 1st to September 30th window, and then they will lose coverage and lose the subsidy, but it'll pop up the special enrollment right for them to go into the healthcare insurance marketplace. And so, we got to go back and we got to track those dates. There's an open question on this too. And the DOL notice kind of suggests that DOL is headed in this position, but as typical, DOL doesn't come out and say so explicitly. There's this concept in COBRA where you can have an extension of coverage, and the two classic fact patterns that trigger that are a disability or a secondary qualifying event, such as a death or a divorce. And it's not clear whether or not somebody who has that special enrollment right can have a disability or a second qualifying event and be able to go past that original 18-month period. This is, again, I wish DOL would have been more specific on this point, or the IRS will hopefully give us some guidance there. But that's, that could potentially move back the date much earlier than October 1st of 2019 for the, as DOL refers to it, I think in the FAQs, the general rule. So I'm not trying to make everybody's head explode, but these are things that we may see guidance on.
So as a practical matter in the interim, just going back, for the folks who pre-April 1, 2021 lost their job, what's the best way, or what's a practical way to track this and to make sure that people are aware of their COBRA rights?
So this is one of those convoluted, there should be an easy answer, right?
Mm-hmm.
That whoever you have as your COBRA administrator is going to have when they initially sent out the records and whatnot. So that I would work with the COBRA administrator to make sure that anyone that had an involuntary termination in that period of time, going 18 months back, is getting the new notice. If you haven't heard from your COBRA administrator, you probably need to reach out to them right away. You should have heard from them by now saying, hey, this is the situation we have. They may ask you, I have one client that they're asking to confirm certain information. But you should have information that you've received from them. They should be able to handle the notification and know who needs to be notified. One thing that came up, and Amy, actually, we were talking about it earlier. The question is, how much do I have to be involved if I have a third party doing my COBRA administration? And this doesn't really change any advice that I wouldn't normally give on COBRA, and that is you are ultimately responsible for everything. So, you don't necessarily have to handhold, but you want to make sure that they're doing what they're supposed to be doing. And generally, like I said, they should have contacted you by now. If they have not, you need to reach out to them as soon as this is over, to make sure that they're doing what needs to be done.
Ooh, I see some questions that I think even I can answer. Okay, I'll just tick them off. Is the new COBRA eligibility only medical, or does it include dental and vision? It does include dental and vision. I know
Yes,
that.
It does.
Boom. Here's another question. I guess Amy or I can try and tackle this one. This is from Tandy, and someone gave a thumbs up to Tandy's question, so I think we need to get to it. Let's assume you have one of those handbook policies that says no call, no show for 3 days. Your employment is deemed to have ended because we accept your resignation of employment. Is that a voluntary separation, or is that voluntary or involuntary for purposes of COBRA? I mean, I don't think.
And I would think
that's
that's involuntary, but not gross misconduct. I think they'd still be eligible for the COBRA benefits, wouldn't you?
Oh, I was going to go the other way, but Mark looks like he's
Ooh.
chomping at the bit to tie break. What do you think?
Yeah, that's what.
So
One of those, it
apologies
depends,
there.
right? That's
Yeah. Everybody.
I would say
But
definitely
I mean,
truly, it depends
can
on
I-
what your handbook actually says, first of all,
Right.
right?
Yeah, and
But does it even matter, Mark and Bob? Does it even matter, because the net effect is the same? They're still going to be able to get the COBRA subsidy.
Well,
Well,
for the I'm sorry, go ahead, Mark.
Yeah, you go.
I was going to say it does matter, because if it's a voluntary termination, they're not eligible for the subsidy.
Bingo.
So
I-
if it's
There you go.
involuntary, then they would be eligible. I mean, you're correct that they're eligible for COBRA, but they're not eligible for the subsidy if you're going to deem it to be a voluntary termination.
Yeah.
Interesting.
And safety would dictate that you would kind of fall on that line, on that side of the line. I also think it would be, to go back to Eric and Amy's practices, ask them what the state specific rules may be on that, because that could potentially inform us about what a legal determination is in another area of law that may kind of bleed over and impact the subsidy.
I think it would
yeah, I think
depend
that's a
on the
great point.
reason, right?
What's
It
that?
would depend- I think it would depend on the reason they finally gave of why they couldn't return. I mean, I understand that it looks voluntary because it's a no call, no show policy,
Mhm.
you know, but I know this is going to surprise some of the HR folks out there, but not every single employee within your company reads your employee handbook. I know, it's a shock. So I think they'd be surprised to see that it was voluntary, and I don't know that it would be deemed voluntary just because, you know, we say that, so it depends.
There we go.
Uh,
There we go. So, Mark, you were talking a little bit about the look back, and then some of the, were we talking a little bit, I see in my notes here, were you talking yet about the after acquired coverage under COBRA?
Yeah, we've talked about the after acquired coverage. I mean, we know for sure now that from DOL's FAQs and the notices that if you subsequently become eligible, you don't have to enroll in, you subsequently become eligible for new coverage under a new employer, your spouse's coverage, or Medicare, you know, that'll stop the subsidy and stop the right, and will stop the COBRA right there if they've elected on. And so there's actually a penalty for the participant if they don't notify the employer or the plan administrator of, you know, that the mere eligibility for that right to join that coverage. The marketplace will not stop that. So if they've gone out into the marketplace, they can be in there simultaneously. You know, in addition, if they go out onto the open market, not through the marketplace, and acquire coverage and they're paying for that, that won't stop it either. It's group medical coverage, either through an employer or the spouse that will do that, or Medicare.
Should we talk a little bit about, well, actually, I want to ask a couple more questions about the FAQ.
Mhm.
Bob, was there anything in the FAQ that surprised you that was unexpected, or was it pretty much what you were looking for?
So I was surprised that there was nothing that surprised me. How's that?
Oh, that's good.
I think I told Mark earlier, it for once it really fell in line with what I was anticipating. I don't know if Mark had anything that took him by surprise.
The thing that struck me is there's a lot of discussion in the FAQs and in the notices about interaction with the marketplace. And as we noted earlier, this wasn't around back in 2009 when we very first experienced a COBRA subsidy. And I think it's important to read through and understand the interaction and the special enrollment periods and everything. But, you know, if I'm the plan administrator as the employer, I don't think that I would get into the business of going in there and trying to get into the nuances of that in terms of rewriting the notices, because these are safe harbors under DOL's rules. And I don't know that I would be really excited if one of my clients goes out and starts counseling employees on how that works. You know, because, you know, those rules are nuanced, and, you know, if you don't satisfy all of the requirements, they're going to have to, you know, they're going to have to potentially wait to another open enrollment period. You know, I realize that, you know, we've got a continuing open enrollment period because of the crisis, but you know, I don't think I would be offering much advice about that, nor would I want my third-party administrator to be offering a lot of advice to individual fact patterns to participants.
Were there any questions in your mind that weren't answered in the, we talked about a few already, but on top of what we've already discussed, are there any unsettled questions or unanswered questions regarding the COBRA premium assistance provisions out of the FAQ?
There's certainly things that I would like to know. For example, there's been discussion and commentary from the plans community of whether or not a voluntary termination for quote unquote good reason could equate to an involuntary termination. And so these are instances, and we see this in 409 Cap A of the code with executives. So if they're demoted, if their pay is substantially cut, they're asked to move, certain events that are very detrimental, so much so that the Internal Revenue Service, at least in the context of 409 Cap A, has said, this is going to be an involuntary termination. And so there's been speculation around that. So we would, ideally we'd like to know these types of things. And of course, the extension due to a disability or a subsequent qualifying event, I think is critical because, we may have to dig further back than just the 18-month period. And then we would rather know that now as we're getting ready to go live, as opposed to later.
There's a question that was just asked, and this is a good one because I'm drafting a few of these agreements myself recently.
And Mark and I have talked about this recently, actually.
Okay, so I'm going to toss this to you, Amy. So here's a question from Kelly. If an employee is terminated involuntarily and the employer offers a severance package that says that they will cover COBRA premiums for a given period of time, so that's part of the consideration for the general release that the employee is going to give. Can the employer then file for the tax reimbursement for the premiums from April to September if the employee is not eligible for other coverage, and then start covering the premiums again from October to December, if that makes sense? So you get your subsidy up through September, and then after that, the employer will cover the premiums. Does that all work?
So I have a lot of thoughts on that. My first thought was wondering if it would still be part of the consideration, but then I see the fact pattern that Kelly's asking is there would still be a few months at the end where the employer would be covering it. As everyone knows, consideration for a severance package has to be something that the employee is not already entitled to, right, by law or contract. So that's a question I had when I looked at the FAQs. And my question was really, how does this affect severance agreements? Eric and I write those all day long under different circumstances. Sometimes COBRA premiums are involved in the consideration and sometimes it's not. But I don't see anything in the FAQs that say anything about the impact on separation agreements, severance agreements. So I don't see anything prohibiting employers getting the premiums during that time, getting the premiums covered. I'd be interested to know if my partners did.
I can tell you what I've done in some of my agreements is I don't make the COBRA, at least recently, because of what's been going on with the COBRA subsidy, I don't make COBRA reimbursement part of the consideration. Generally, I move that up to a section of the agreement that says, regardless of whether you sign this, you maintain the rights under COBRA. And then if you as the employer are concerned about the employee signing it because, are you giving them enough? Just throw them an extra couple of bucks. I mean, even before all of this, sometimes what I would do is instead of having some kind of COBRA reimbursement provision in a severance agreement, I would just scrap that all together and say, look, we'll give you 2 weeks for every year or whatever, that's the first part. And then in lieu of COBRA reimbursement, here's an extra couple $1,000. Do with it as you want, right? Here's an extra 5,000, do whatever. And that's it. And there's your, your consideration.
That makes sense, but are there tax implications there?
Yeah, that's true.
Right.
Yeah, those do, they do interact with 409 Cap A too. So that needs to be kept in mind, not to get off the reservation on that. Yeah. Another thing that I noticed that was kind of unexpected for me is there is a concept in here of the joint notice that was issued by DOL, the IRS, and Health and Human Services about extending election periods and notice periods for the pandemic. And that notice basically extends it for up to a year. But interestingly, in the subsidy, that exception doesn't apply. And so you could have people that have a longer COBRA election period under the notice than they would have under the subsidized COBRA. So you could have people that are falling outside of the notice period for being able to obtain the subsidy, but have that election right under the joint notice. And then presumably those people are not going to be entitled to the subsidy. Now I can see that as one period, one enforcement position that the DOL and the IRS, or particularly the IRS, could take, because I don't think that the employee or the employer would be able to go in and claim the credit for the subsidy for people that elected outside of the election period that's set forth in the FAQs and the notices that the DOL has provided to us. So that's another kind of trap for the unwary. Thankfully, that's discussed in detail in the FAQs and in the model notices.
Folks, we have a question that just came in. If an employee and their dependents are all AEIs, then the employee becomes eligible for Medicare. Would the dependents continue to receive the COBRA subsidy?
Yes.
That was easy.
Yeah, this is a separate rights kind of concept that's embedded in COBRA. It's hardwired in. It was baked in originally, and so each person travels under their own weight and their own rights. So as long as the dependent was covered by the group medical plan, lost it because of the termination involuntarily or a reduction in hours, then they're going to have that COBRA right, even if somebody subsequently gets covered. Because keep in mind there too that the child would not be eligible to qualify for Medicare, presumably. I mean, they're going to be too young. And Medicaid doesn't count. Just going into Medicaid or CHIP doesn't stop the COBRA either. Only after acquired coverage. So if you change that fact pattern, and then the employee, instead of going on to Medicare, went into a new employer's plan, and the child is eligible, mere eligibility at that point should stop it. But those are all traveling kind of as separate rights and need to be pulled out and teased out individually.
What about children aging off the plan? How does that work here?
Yeah, that's a difficult question. And that really is this kind of concept of why you lost coverage. And so, I hadn't really thought about this one, but perhaps, and I don't know off the top of my head, but it may be the case that if you have a child that is initially eligible for COBRA under the subsidy, but then they age off of that coverage, if that would otherwise be a second qualifying event, that would either extend the period or allow them to continue on longer than what everyone else who is otherwise elected COBRA based upon that employee would experience.
Okay.
And there again, just be helpful if we knew those rules. But that's in the weeds.
We were talking offline before we went on to the Zoom today about the interplay between, or the potential interplay between state, mini COBRA wouldn't necessarily interplay with COBRA because you have different numerosity requirements, but there might be state healthcare continuation laws that could interplay with COBRA. Have you guys, any of you thought about that and how that might work going forward? Or is that too state specific to give a really general answer?
Yeah, I mean, you're going to have to go in and you're going to have to look at the mini COBRA because we know that the subsidy applies there. We know DOL has said, the subsidy applies, but I think it's the case that we don't know if there's going to be a special election because the special election strikes me as, that's applicable to COBRA. It wouldn't be per se applicable to being able to go back and retroactively elect state mini COBRA. And mini COBRA, keep in mind, for small employers typically, that's fewer than 20 employees. And then, that's kind of there to bridge that gap for COBRA not covering it. But some states have more expansive coverage rights. And so depending on, if you're an employer who operates in multiple states or unfortunately all 50 states, and you have insured coverage out there, you're going to need to kind of understand that and check those rules out there, because the subsidy does apply. I would expect that most of the people will be covered through the COBRA anyway, but it's nevertheless out there as an issue.
I have a question. This is just me, and maybe this is me being naive. What if the employer what are some of the penalties for the employer if they make the wrong determination about COBRA eligibility, COBRA subsidy eligibility? They should have gotten it, but they didn't. What's the downfall there for the employer? So someone I assume at the end of the day has to say, whether it's the plan administrator or fiduciary, has to say, you get it or you don't. What if you mess that up?
Bob, you want to handle this? We talked about it a little bit.
Yeah, and I guess the determination once it's made, I mean, the failure is what is $100 a day up to $200 per family. So that's why it's always, to err on the conservative side when making those determinations, but because it is per day. But I'm just trying to think as far as who's making the determination. I don't necessarily know if it's going to be a determination issue, if it's just going to be a we missed it issue. That's what I'd be more concerned about. Is I go back and we're going to send out our notices, the updated notices to only certain people, that we somehow misclassified somebody. And all of a sudden we're on the hook for this really large penalty a year, 2, 3 years down the road. I mean, the government's behind on penalizing most people, and you're getting, in our world, we're seeing penalties 3 or 4 years down the road just because of the way things are working out.
Is there a private right of action for that?
I'm sorry?
Is there a private right of action?
No, not that I'm aware of. I mean, Mark, have you seen anything going beyond?
Yeah, you got a couple of things in play there, because if you don't give them their notices, you're not triggering the deadlines for them to elect. Now, at some point, they pass the coverage period, but the problem there is if they didn't elect coverage, but or they didn't get the notice, but they should have gotten the notice, and they go out and get in a bad accident. Hospitals and healthcare providers, I mean, that's one of the questions they're going to ask, and it's not uncommon to see a hospital come in and file COBRA and get COBRA coverage on behalf of an employee. Now, if you didn't properly administer that from in a group insured product, in other words, you're not a big employer, so you're self-funded, but you have insured coverage for your employees, and you've shifted that risk over, I can see a situation there where the insurance carrier, if they weren't responsible for all of this, they didn't have dirty hands, are going to come back and say, this is too bad. We're not covering this. This is on your dime, employer. So effectively, you might be able to walk yourself into self-insured coverage without stop loss. So you could be staring down the barrel of a pretty big bill. And even worse yet, you're not going to be in any network. So you're not going to be able to get network discounts. That could be a cataclysmic event. And so, I've never seen it, but I could certainly see there being a lot of dollars at stake there.
And I was going to say, and that's going to be, Amy, to answer that question. It's COBRA in general. Anytime you mishandle, don't let them in. It's not necessarily tied to. I'll be curious if something happens within the subsidy. I have seen where somebody said that they weren't eligible, didn't get the enrollment information for COBRA. They had an accident. They went back and had to pay for everything because, like Mark said, it's out of the contract. but yeah, the subsidy and not giving it to them, it would just go back to an enrollment right that would trigger COBRA. I mean, that COBRA liability.
Yeah, and there's another point here too, is that the $100 a day up to $200 a day for the failure is an excise tax. DOL is taking the position that they're going to be, enforcing this aggressively, which means that they're encouraging the participants, if you look in the materials, to call the Employee Benefit Security Administration field offices. And anytime you've had EBSA in the field office calling you, trying to cajole you into doing something, the default is always, in my experience, been that the employee's right and the employer should do whatever the DOL thinks that they need to do, when that may not be what that law actually says. And on the point of the excise tax, the statute of limitations doesn't run on an excise tax under federal tax law until you file a return. And so, what you will get into there if you find a violation is, this untenable position of having to go out there and file an excise tax return and either pay the penalty or argue reasonable cause. And, that's just going to be a thankless task because, presumably you're going to have somebody in-house, your accountant or outside benefits counsel that's going to be going in and having to clean up that mess. And that's truly a situation where the cure is worse than the disease. So.
Riffing off of that last question, we were talking about what's the downside to the employer if they mess up. But if they're too permissive, Kelly asks, little conservative, they provide the subsidy and it's someone who was terminated for gross misconduct or someone who left voluntarily, what's the risk there to the employer if the employee gets the subsidy but really isn't entitled to it?
I think that's going to be an IRS enforcement position. And I mean, I don't know the degree to which the IRS is going to be able to devote resources into going back and checking to make sure whether or not the subsidies were correctly taken. We've seen abuses in the Paycheck Protection Program where they've gone after people that took money and went out and bought boats and fancy cars and stuff. But given the current climate and circumstances, I don't know that the IRS is going to have the folks to go out there and to enforce it unless they start to see, really bad misuse of it.
Yeah, I think the IRS is going to be able to figure out those people who are eligible for other coverage, and get money back from those individuals. I think as far as making the determination if it was really voluntary, involuntary, when I say err on the conservative side, I'm going to, kind of lend that to the employment guys. And that is, you get in those situations that we discussed earlier, where the handbook says that it's an involuntary termination. Are they going to argue it and say it's, ends up being, a voluntary termination, when in reality, it's probably going to be deemed an involuntary termination. You don't want to get hung with that $100 or $200 day penalty because you got your facts and circumstances wrong or didn't talk to an attorney to get their opinion on whether or not your handbook was going to suffice to be there, if that makes
Based on the facts of
yeah,
the actual situation.
exactly. I agree with Mark. I can't imagine the IRS having the manpower or even the will to want to go out and go into each individual employer and say, hey, I want to see why this person was terminated, make sure it was truly involuntary. I think they're going to be able to make enough of it up on the other side of, people being eligible for coverage. And that's something that they can track without it putting a whole lot of manpower into.
Yeah, because the employers are having to turn in that coverage notice under under Obamacare. And so, they can program their computers to triangulate that. The service for years has been under the starve the beast theory from a political perspective. And, by not allocating resources for them to have a robust enforcement program, it's really a voluntary system in terms of enforcement. So unless there are gross abuses that start hitting the press and stuff, I just don't expect that the IRS is going to mess with it.
Yep.
Hey, Amy, there was a question here about an employee resignation, but it's due to medical issues. So they just can't come back. And that maybe think about FMLA. And we have someone who goes out, does their 12 weeks, maybe it's a terminal illness, and 12 weeks are up. There really is no reasonable accommodation that will allow that individual to do the essential functions of the job. Essentially, what their doctor says to the employer is, my patient needs indefinite leave. So the employee can't come back.
Yeah,
You did some looking into the FMLA COBRA interplay. Can you
I
address that?
did.
Yeah.
I did, sure. There is a regulation that addresses that actually, and what the skinny is on it, and then I'll tell you about the regulation, is FMLA is not a COBRA qualifying event. But a qualifying event could occur if the employee doesn't return to work or notifies the employer of that employee's intent not to return to work at the end of the FMLA period. Okay, in which case a qualifying event occurs on the last day of FMLA leave. And that pretty much tracks, the regulations. And it's actually a regulation with a Q&A, which I've quite never seen before. It's really under those specific circumstances that the employee just can't come back. That triggers that qualifying event where they'd be eligible for COBRA.
But Amy, is that a involuntary termination, or is that we know we've got a reduction of hours, but is it an involuntary termination, I guess?
Right, right. If they can't come back, I think that that's a gray area, don't you?
Yeah, I do.
I mean, I think it's easy to say that it's voluntary, and certainly, the FMLA is a leave statute with the intent that the employee is going to come back with or without an accommodation. And certainly under the FMLA, under the ADA, you may have to provide extensions of leave, and employers have to deal with that all the time. But if it comes to the point where they can't come back, I don't know. I think that could be, a highly litigated issue, in the future. Under these regulations, where that distinction between voluntary and involuntary makes the difference between getting the subsidy or not, and that penalty that you keep talking about.
Yeah, and I mean, that's where if we had a good reason definition that interplayed with an involuntary termination,
Exactly.
it would give us a lot to go on there in terms of certainty. But again, if you do go ahead and extend the coverage, we think that we think it's probably unlikely that there's going to be much enforcement action.
So would you say it's the best bet for employers in that situation to just extend the COBRA coverage?
I think that's a business decision. I mean, I think that's where we sit down with our clients and we explain the risks, and they make a decision based upon the risks and the rewards.
Got it.
Let's do a quick reset. We got about 10 minutes left. This is the Employer Handbook Zoom Office Hour Beverages and Benefits Edition. We're talking COBRA subsidy. We've talked about the DOL FAQ. We've talked about the model notices. We've done some Q&A throughout. I'm Eric. There's Mark, Amy, Bob. We've got about 10 minutes left. If you have questions, please throw them up in the chat. If you're watching this on YouTube, I hope you like it. If you do, consider subscribing to the channel, liking the video, and comment below. In the last 10 minutes, I'll go around the wheel. Takeaways, just some general takeaways from the updated guidance, from the model notices, either legal or practical for some of our folks watching here today. Bob, I'll start with you.
So one thing that I think we need to say is, normally if someone goes back, let me reset. If someone decides that they're going to get the second bite at the apple and take COBRA starting in April, it will start in April. It is not retroactive to the qualifying event. So they can't get coverage for November, December, January. It will start April 1st. So they won't have to pay the prior 4 months premiums to get it going. So that is one big thing. I think the other thing is just watching COBRA, your COBRA administration, and that's no different now than it is any other time. I just think it's going to be very important to make sure that you're not missing, that you don't miss anybody getting the second notice and getting the second bite of the apple in order to avoid as many penalties as humanly possible. There's other issues as far as, but we're not going to solve those. And I don't necessarily think we're going to see any additional guidance on what's going to be a reduction in hours and what's going to be good for that. And Mark may disagree, but just in a general world, we've been waiting on really clarity on some of those issues for 20 years. So I just don't see him doing anything now. But those are my three little things. The main thing is, from a practical standpoint, just work hand in hand with your COBRA administrator to make sure that everything's going properly, and be cautious.
Yeah, and I noticed that Carolina, but pronounced your first name correctly. You said, do employers have to refund the COBRA payments already paid during a subsidy period? DOL specifically addresses this in the FAQs. And they say that you could either offset any future premium payments that we would have if their COBRA period extends beyond the subsidy and they choose to do so, or as appropriate, the employer would refund that money to the employee. And so, there's a position out there for employers to take on that. One of the things that I think is a good takeaway is, don't forget about this notice of the expiration of the period of premium assistance. You have a 14 and 45 day rule, so it can't be provided, that notice can't be provided more than 45 days before the subsidy ends, and no less than 15 or 14 days. Well, keep in mind here, you're going to need to track those, and this includes people who are retroactively have a special election right, when that COBRA is going to end, because we're going to need to be able to provide them with that notice no less than 14 days. And so, I tended to originally kind of put that on the bottom of the pile in terms of the notices, but then I started thinking about it. Well, we need to start tracking that date now, because we may have people that are well within, or we may have already had people whose natural 19-month period is going to otherwise expire in a couple of days. And we're already outside of the notice period. I poked around a little bit. I didn't find much on this, but I would assume that, that would be a notice penalty issue. So, that's something to consider and something to ask your third-party administrator about what their position is on that. We've given you, quite a few kind of nuanced issues that, perhaps you can go in and when you're talking to your third-party administrator or the carrier, you can kind of quiz them on some of these issues to see what their position is. And that will kind of give you an idea of how well prepared they are.
This is where your TPA earns their money, for sure.
It's interesting. What about the notices, Bob and Mark? Like, is it clear on the FAQs and on the DOL site which notices apply in which situation, which model notice?
And Amy, thanks for pitching me the softball here, because I've already complained about this. We've got about three notices. We've got one that's peculiar to going back and picking up the people, whether they were insured or not, who didn't elect COBRA or it lapsed. Then we've got a separate election for people who experience a qualifying event from April 1st until September 30th. And those notices differ in many respects. And so what you can expect is hopefully the TPA is going to kind of follow that same parameter. We also have a notice that is just for insured coverage for continuation from April 1st through September 30th. And so you're going to need to, somebody's going to need to read through and be able to digest and be able to delineate what class of people are going to go into what notice.
Right.
And so that's one of the implementation things that you're going to need to talk to your third-party administrator about, and make sure that everybody kind of has a meeting of the minds with respect to, which notice we're going to use for which people and how the system's going to be able to shuffle the people into the correct notices.
It looks like a couple of questions have come up regarding the notice, and that is, everyone who had that qualifying event dating back those 18 months should get a second notice, whether they elected coverage at the time or not. And so, as Mark just stated, some of them have let it lapse, some decided not to, but they're going to have a second chance to get into COBRA effective April 1.
And Louisa, I noticed she's asked a really good question, and this goes back to just basic COBRA principle. If the company is closing and all policies are ending on 5/31/21, how does the company unravel this for a short time? Under the rule under COBRA, if you're no longer offering coverage, then coverage goes away. That stops the COBRA right there. So there would be no subsidy, no COBRA. It just, all policies are terminated.
Yeah. Again, the subsidy doesn't change anything. It doesn't change the COBRA regulation. So if COBRA doesn't exist, then they can't get they can't get a premium subsidy. So.
Well, I think that just about, oh wait, no, here, I just, some basic other questions. At this point, this ends for everyone on September 30, right? There is no discretion afforded to the DOL or anyone to extend the COBRA subsidy beyond September 30, correct? This has to be done by Congress?
Yes, correct. This was done by statute. And so that is, that was baked into the statute. There is kind of a nuance there. So, it'd be for premium periods paid on or before September 30th is what I would use probably as a general rule of thumb. And so, our COBRA premium is going to be, as of a specific day in any given month. And so, anytime we're playing with time like that, and we're dealing with a hard date in terms of April 1st or September 30th, then, I would just look at that, when that premium's paid, if that premium would have ordinarily been due on or before September 30th, but the coverage extends beyond that somewhat, I would probably go ahead and treat that as being subject to the subsidy. Because, keep in mind your payroll people, and this is another point, you need to coordinate with payroll. Because the way that the employer is going to get reimbursed is through a 941, and there we can go back and look at the old 2009 reporting positions that were taken. But those are all bridges that you're going to have to be crossed whenever the employer files its returns to be able to get the subsidy reimbursed or the credit.
Yeah.
All right.
Interesting.
Well, folks, I added everyone's contact information in the chat window. Connect with us on LinkedIn. Before I turn it over to each person and do their own little plugs, I want to plug next week's Employer Handbook Zoom office hour. Special guest is going to be Susan Warner. Susan Warner is another partner of ours, the Employment Practice Group, but she had what I think is the biggest Americans with Disabilities Act win of 2021. It is a Title III ADA case. So not your workplace, Title I, reasonable accommodation, qualified individual, that kind of stuff. We're talking about Title III, and it has to do with whether your business's website is covered under the ADA as something where you have to provide an accommodation for people like who have vision problems, blind. Very important issue. This transcends beyond websites. We'll talk about Title III generally, these types of drive-by lawsuits where if you've ever had to defend them, they are a pain. So this is one really you don't want to miss. This is, my partner won the biggest case in the ADA in 2021.
For employers.
Yeah.
For employers in the Southeast. That's pretty amazing. And as from a litigation perspective, just so you know, We have clients getting dinged on that right and left on whether their websites are ADA accessible or not. That is a very hot topic among employment law litigators.
Yep, we can speak to your websites, we can speak to your physical brick and mortar infrastructure.
Yep.
As to how to handle those types of lawsuits. So please do tune in next week, Friday at noon. So let me again go once around the wheel. I'll thank Mark and Bob and Amy for all their time. They're so generous with their time today. Anything you guys want to plug?
Yeah, just give us a call.
All right.
I was gonna say, I'm gonna throw out all things ERISA. If you just can't get enough information on employee benefits or anything, I'll put it in the chat room right now, but allthingserisa.com, and we just update it with things that are going on.
Yeah, and for me, it's a bite of gratitude for the deep bench we have at FisherBroyles, that we have employee benefits partners who can really dig into the weeds on this type of information. A lot of the times you all call your employment lawyers, and that's great. That's what we want you to do. We call our employee benefits partners, who are always upfront on it.
Awesome. Awesome. All right, folks. Well, thank you so much to everyone who came out today. This will be, again, uploaded to YouTube. Tell your friends. I've dropped a link in the chat to the Employer Handbook YouTube channel. We'll put it there. When you watch the video, be sure to like and subscribe and all that good stuff. Otherwise, have a great weekend. Stay safe, and hopefully we'll see you next week. Bye.
Thanks, guys.
Thank
Thank you.
you.